In 1987, during the Constitution's bicentennial, there was much celebration over the fact that we had the oldest written Constitution on earth. Over the years since then, I have come to believe it was a little overblown because the Constitution has changed so greatly from the one written in 1787. But the same basic principles are there, the principles of self-government. Changes in the Constitution often cause meaningful change in our society. And changes in our society are often reflected later in changes in our Constitution. So change is a two-way street. The Constitution changes society, and society changes the Constitution. Those changes, for the most part, were a great improvement and reflect the virtues of America. The Constitution changes in three ways. First, through tradition. Secondly, through Supreme Court case law or decisions. And finally, through constitutional amendments. We will be studying the last two, case law and amendments. Marbury versus Madison, an early Supreme Court case, made many of these changes possible. If all you remember about Marbury versus Madison is that it gave us judicial review, then you are 90% of the way there, but the facts are worth understanding. Now, John Adams left the White House March 3, 1801, but he and his Secretary of State, John Marshall, left a stack of commissions to be delivered by the incoming Secretary of State, James Madison. These commissions were for magistrate positions. The Senate had already confirmed these appointments as required by the Constitution. They were for federal magistrate positions that were low level. Thomas Jefferson was sworn into the presidency the next day, March 4th, 1801. These magistrates were all Federalists, and the new administration were Democratic Republicans. Well, I think you see the problem arising here. James Madison could not bring himself to deliver these Federalist commissions. William Marbury, one of the intended recipients, sued Madison to get his commission. He pursued his claim directly into the Supreme Court, asking for a writ of mandamus. Now, Congress had passed the Judiciary Act of 1789 a few years before, and it said that people like William Marbury could go straight into the Supreme Court and seek a writ of mandamus. This is an order from the court, a writ of mandamus, which mandates or orders someone to do a specific act. This fact will be important, as we shall see later. What happened next is, as we say, history. When this case came before the Supreme Court in 1803, President Thomas Jefferson and his Secretary of State, James Madison, figured they would lose for sure. In fact, they did not even go to the hearing or send any attorney. In deciding the case, Chief Justice John Marshall faced a terrific predicament. If he told Marbury he should get the commission, John Marshall had no way of enforcing his decision. And President Jefferson and James Madison, who despised the Supreme Court, would ignore the order to deliver the commissions. That would crush Marshall's dream that the federal judiciary should become a powerful branch of government. On the other hand, if Marshall ruled against Marbury, everyone would know that he was doing it only because he did not want to issue an unenforceable order and be embarrassed when the president and others ignored it. So John Marshall, a man without a law degree, did something that shows why he is still considered the most brilliant Supreme Court justice in our history. He embraced a solution that would protect the Supreme Court from embarrassment, condemn the failure of James Madison in not delivering the commissions, yet also expand the power of the Supreme Court enormously. Here is how he did it. Marshall read his decision in open court and began with a long explanation as to the fact that William Marbury had a right to the commission and James Madison had a duty to deliver it to him. He stated that the proper remedy is a writ of mandamus. He slaps the hand of James Madison very strongly in his opinion, so much so that William Marbury must have been certain as he heard this decision that the decision was was that he had clearly won. Then Marshall makes an observation that turned the case on its head. He points out that while Madison had a duty to deliver the commission to Marbury, Marbury was in the wrong court for relief. Remember that Judiciary Act of 1789 I told you about a few minutes ago? Well, giving Marbury the right to go straight into the Supreme Court for a writ of mandamus is what that act did. That act contradicted Article 3 of the Constitution, which states that except for cases affecting ambassadors, ministers, and consuls, and where a state is a party to the suit, the Supreme Court only has appellate jurisdiction. The Supreme Court doesn't have original jurisdiction, except in limited cases. This meant that the only way Marbury could go before the Supreme Court would be if it were first heard at a federal district court, and then it would be appealed up to the Supreme Court possibly. So despite how right Marbury was, he would have to leave the Supreme Court and go way down the chain and start all over again. Congress simply did not have the power to pass a law which contradicted the United States Constitution. It was the duty and right of the Supreme Court, when confronted with that portion of the Judiciary Act of 1789, to declare it null and void. This is how the principle of judicial review was born. Thomas Jefferson was livid. You might be wondering why he would be angry. He had won his case, hadn't he? Marbury, his opponent, was tossed out of court, but Jefferson was angry because a precedent had been established by this decision that the judiciary could review laws passed by the legislature. The Constitution never mentions judicial review, and its existence was in doubt prior to 1803. For Marshall, it was a great political coup. But was this a radical idea? Not in the least. The British had been practicing this principle for centuries. In our country, many states spelled out the principle of judicial review in their state constitutions. Even the Federalist Papers addressed this principle favorably. One of the most powerful institutions shaping this nation since 1803 has been the federal judiciary and the Supreme Court, and the power to do this is all traced back to that one decision, Marbury versus Madison. Our next case we will study is Fletcher versus Peck, a case which has shown up on the multiple choice part of the AP US History test more than once.